Good morning, everyone. In person and online, good morning and welcome to the Max Bell School. My name is Chris Reagan, and I am the director of the Max Bell School. I'm an economist by training, and I don't know whether that means inevitably I know nothing about human rights or it's just me that knows nothing about human rights. So I will bring zero value to today's event other than the introduction. Pearl has asked me to introduce and welcome and to do a land acknowledgement and some thank yous, and I'm happy to do all of that. Those of you who know Pearl know that it's very hard to say no to Pearl. So even if I wanted to say no, I wouldn't be. So here I am. Let me begin with a land acknowledgement. The Max Bell School of Public Policy and all of McGill University are situated on the traditional territory of the Kanagahaga, which has long served as a site of meeting and exchange amongst Indigenous peoples. Now, most, if not all parts of Canada are on the traditional territory of some Indigenous peoples. During COVID, and I like to think about COVID in the past tense, during COVID I hosted some Max Bell events while I was sitting in my summer place in Gimli, Manitoba. Now, Gimli, Manitoba is an unremarkable prairie town located on the shore of a quite remarkable prairie lake. 150 years ago, the local Indigenous people called it an inland sea, and those of you who have seen it will know why they say that. So, hosting those events and thinking about a land acknowledgement from Gimli, Manitoba led me to learn something about local things. And I learned that Gimli is located on Treaty 1 territory, the traditional territory of the Anishinaabe and the Swampy Cree Indians, Swampy Cree nations. Now, the Treaty 1 caught my interest. It led me to wonder why was it first and how many treaties were there. So I turned on my computer and I did a little bit of reading, where I learned that the Crown signed 11 treaties, which are the so-called numbered treaties, between 1871 and 1921. They signed others as well, but those are the 11 numbered treaties. Now, those readings about those treaties mention the Indian Act, which reminded me, I suppose, that I learned approximately nothing about the Indian Act when I was growing up and going to school in Edmonton in the 1970s. I don't think that was just the Edmonton Public School Board. And I don't think I was just away that day. I think it just simply was not discussed. And then, in a remarkable bookstore in the unremarkable prairie town of Gimli, I stumbled upon this book by Bob Joseph called 21 Things You May Not Know About the Indian Act. Now, those people in the room who are my students, our students here, will know that I've spoken about this. For those of you who have not seen this book, I highly encourage you to get this book, because if you know very little about the Indian Act, you will find that this book is a remarkable, eye-opening, and fairly depressing discussion about the Indian Act. Indigenous people today make up about 4.5% of Canada's population. When you read this book, it should become clear to you that the Indian Act represents far more than 4.5% of Canada's policy errors over the past 150 years. It is really, truly remarkable. So I'd just like to encourage you all to take whatever intellectual route suits you to learn more about the land where you work, where you play, where you live, and to learn more about Canada's history and its treatment with Indigenous people. 21 things you may not know about the Indian Act. Great book. On a more positive note, I have many thank yous to extend for this event. The co-convener, the Center for Human Rights and Pluralism, Nandini Ramanujam, and I apologize if I've just mutilated your name, is here. Thank you very much. Partners for this event, the Canadian Human Rights Commission, Canadian Race Relations Foundation, the Centre for Research Action on Race Relations, and Quebec Human Rights and Youth Rights Commission. Thank you all for participating and partnering in this event. A special thanks to our media partner, the Literary Review of Canada. There is a latest copy on your desk. I noticed there's actually an article in there by one of our teaching staff, David Shribman, but there's lots of other good stuff in the Literary Review. So thank you very much, and I'd like to acknowledge the presence today of the publisher, Ethne McCready. Thank you. And Amanda Perry, contributing editor. Thank you very much. And finally, an extra special thanks to Professor Pearl Eliadis and the members of the Max Bell EDI Committee for organizing all of this event. So without further ado, I'm going to turn it over to Pearl, and we'll get this party started. Thank you.
Good morning, everyone, and welcome. Welcome to those of you who are here in person, and a special welcome to those who are online. I understand we have more than 100 or so who have come into the room, so really grateful to have all of you with us today on these important issues. So I'm going to just do a little bit of a setup. We're going to have with us today the two principal litigators who pleaded the Ward case. So it's just an extraordinary opportunity to have Maîtres Stéphanie Fournier and Maître Julius Gray, two leading human rights and constitutional law scholars who are going to meet again today in front of you. So I'm just going to do, especially for those of you who are not lawyers, or for the lawyers among you who do not follow for human rights, and especially for the economists, I'm going to do a little kind of overview about why this issue matters, and just give you a very brief sense of what the issues have been. So can I get the next slide, please? Thanks, Jonathan. Okay, perfect. Thank you so much. There we go. Okay, so just very briefly, the legal framework. So in international law, as many of you may know, there is a right to hold opinions without interference, the right of freedom of expression, which includes not only expression, but also the right to receive and impart information and ideas of all kinds. And Article 20, which prohibits propaganda for war and any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence, prohibited by law, right? So these provisions inspired the Canadian Charter of Rights and Freedoms. They inspired the Quebec Charter of Human Rights and Freedoms, which the latter of which preceded the Canadian one by, I want to say, 6 years. Canada, of course, has ratified the International Covenant on Civil and Political Rights, the provisions I just showed you. Quebec has also, by decree, considered itself bound to the provisions of international law. Important to remember, again, that the Canadian Charter of Rights and Freedoms protects listeners as well as speakers. And this is something that is going to be a recurring theme throughout our conversation today. So why do we care about freedom of expression? Why do we care about truth? Joseph Raz, political philosopher from Oxford, said very famously once that liberals protect freedom of speech for reasons they don't quite understand. Eric Barrant, who's written one of the leading texts on this issue, talks about truth, something that you will have encountered, especially for the students in the room, in Taylor Owen's class, thinking about information, disinformation, misinformation, why these things matter. Do we care about truth? Why do we care about truth? When do we care about truth? The idea of self-fulfillment, this is going to come through a lot in a lot of the conversations you're going to hear today. That expression is connected with human dignity, equal concern, equal respect. Participation, the idea that political expression is connected to participation and the right of all of us to participate in society, in public debate, and a kind of more, I want to say American, that may be unfair, American distrust of government, particularly seen these days in the right wing. But these are all ideas that are central to the concept of freedom of expression. I want to make a through line, if I may, to those who were involved in the conference that my colleagues Taylor Owen and Jennifer Welsh ran a little while ago, between these concepts of expression and harm. where we're focusing mainly on what's going on online and a through line to what we're going to talk about today. Because the legal principles, which are always in flux, as you'll hear from Julius and Stéphanie in a moment, really are what underpin the conversation about what should and shouldn't be allowed online. And these are principles we've been talking about for hundreds of years. The mechanics of how you manage that, of course, online are very different. Yeah. But these ideas of human dignity, of the right to freedom of expression, and the right to equality, and how those interconnect are really fundamental to our conversation today. And so when we're thinking about what hate is and the hallmarks of hate at the federal level, there have been some clear ideas about what these things mean, that people are worthy of extreme hatred, that people are worthy of extreme hatred and contempt, therefore they should be either eliminated or ignored or excluded from society, messages that trivialize and celebrate past persecution or tragedy, and calls, of course, to take violent action. The speech wars in Canada really started around 2006, 2008. This image comes from a Maisonneuve magazine publication from 2008, and it shows, going from your left to right, Ezra Levant, Mark Stein, and Barbara Emile, all of whom had written in Maclean's magazine during the period between 2006 and 2008 a series of articles that criticized Islam, that talked about what we call today the Great Replacement Theory, that Muslims were going to take over, that there was going to be a bloody takeover of your real estate, and I quote, that Muslims engage in criminal acts, bestiality. Mark Stein talked about sheep shagging specifically. And these were not things that were being done in, as I say, blogs in somebody's basement. These were things that were being put forward in Canada's national newspaper, as it called itself at the time. And supported, by the way, by every single major media outlet in the country. Right now, things have changed today, and things have changed today in large part because of the work of what human rights commissions and others have done to try to change the tone, to try to change the way in which we understand respect and the impact of speech on those who receive it. So I'm just going to run a quick clip, because fast forward to the Ward case 2021, what happens when you take these ideas of equality? Thanks, Jonathan. What happens when you take these ideas of equality and freedom of expression outside of the usual areas where we talk about them, like employment, social services, and the like, put them on a stage? How do we think about the changes that we should be considering to make sure that people are at once in a position where they can be respected, but where the rights of the speaker or the comedian in place take part? So I'm going to run the clip. Jonathan, can I do that?
You may just need to rewind it a bit there. Audio started.
Okay. So for those of you who, this is going to be in French. For those of you who do not speak French or aren't comfortable understanding a pretty rapid clip, we're sharing on the chat a Google Doc that has the English version of what you're about to hear. So Cassandra is going to be putting that on the chat and may have already done so. So please feel free to log into the Zoom and access that if that's something that you'd like to do.
I inadvertently found a problem, which is sometimes good.
And as Jonathan's setting up, the background to the Ward case was a 2013 decision of the Supreme Court of Canada called Whatcott. Whatcott was really the case that, to some extent, ended the speech wars. And the court in that case said that we should not only be looking at essentially criminal law as an option for regulating the harms that are caused by hate, but we also should be looking at other types of remedies, including those offered by human rights commissions in Canada, which are civil, not on the criminal side of the equation, and thinking about the fact that certain types of speech dehumanize the target, make those targets unworthy of consideration as part of the human race. So here we go. Or not. There we go.
Moi, Céline, elle m'impressionne pour une chose. Elle chantait pour le pape. Elle chantait pour le pape quand elle était petite. Il n'y a aucun autre... Ben oui, il y a un autre enfant québécois qui a chanté pour le pape. C'est le petit Jérémy. Je sais pas si vous vous rappelez, tu sais, le petit, là, qui avait comme un subwoofer sur la tête. Là, lui, t'es écœurant. T'allais à côté, tu vas entendre les commandes à l'auto du IW. C'est écœurant. Puis il était un petit peu moins bon que Céline. On se le cachera pas, là. Il avait une voix un petit peu moins mielleuse, là. Il est arrivé, puis il a fait comme un papa, mais il faisait de son mieux. Puis moi, je me rappelle, au début, tout le monde voulait le comparer à Céline. Hein, au début, il est arrivé, tout le monde l'insultait, j'étais le seul à le défendre. Il arrive, il chante pour Céline, pour le pape, puis tout le monde a fait comme, il est bien poche, lui. Chris, il est poche, il fausse, il chante mal, il est mauvais. Puis c'est comme, asti, il vit un rêve. Il est mourant, puis il vit un rêve. Laisse-le vivre son rêve. Son rêve, depuis qu'il est petit, c'était de fausser devant le pape. Et là, il est en train de le réaliser à merveille. Laisse-le vivre son rêve. Après ça, il a chanté pour Céline à Vegas. Même monde, en fait, asti, qui est poche. Il est poche, il fausse, il chante mal. J'étais comme Chris, il est mourant. Il vit un rêve. Laisse-le vivre son rêve. Asti, c'est un enfant mourant qui vit un rêve. Laisse-le vivre son rêve. Il a chanté pour les Canadiens. Hein, il avait scrappé l'hymne national. Et là, le monde, en fait, asti, qui est poche. Il fausse, il chante mal. J'étais comme Chris, il est mourant. Il vit un rêve. Arrêtez de l'insulter. Il vit un rêve. Laissez-le vivre son rêve. Je le défendais, puis j'ai pas arrêté de le défendre. Sauf que là, 5 ans plus tard, Chris, il est pas encore mort! Il meurt pas, le petit tabarnak! Moi, je le défendais comme un cave, et lui, il meurt pas. Moi, je te défends, toi, tu crèves, câlisse! Asti de 100 cœurs! Puis, il est pas tuable! Je l'ai vu l'été passé à Bromont, au glissade d'eau, j'ai essayé de le noyer. Pas capable! Pas capable! Je suis allé voir sur Internet, c'est quoi sa maladie? Tu sais quoi qu'il a? Il est laid, asti!
So that's the clip. That's an example of some of the productions or shows that were given by Mike Ward. And there are really important questions about whether or not this goes beyond the line, whether or not this does constitute speech that incites discrimination. Is there a distinction between discrimination and hate? Why does that matter for the conversation around freedom of expression? How do we balance these ideas of equality, freedom of expression, and a society that values the culture of human rights, but at the same time make sure that we have liberal, open, and free conversation and discussion? These are not easy questions, and two of the people who are, I think, best placed in this room in the first panel to talk to us about this are Stéphanie Fournier and Julius Gray, and I believe, Julius, you are up first. So, Julius, would you like to join me up here? And we're looking forward to hearing from you. Thank you so much.
I know it's not related.
Thank you very much for this invitation. Thank you, Pearl. Thank you, Chris, because instead of the usual mechanical acknowledgement of land claims, you gave us some reading material, which I will certainly try to read and to learn more about that issue. But when it comes to Mike Ward, I think the issue is not technical rules of law, differences between Quebec law, for instance, with its dignity provisions and the Canadian Charter. In fact, the Supreme Court said it doesn't matter, the principles are the same. It's a political principle. Remember, separate but equal was equal in 1895. It was unequal in 1954, but the Constitution was the same. So it's not technical legal law. It's the issue of what should be happening in a reasonable, free society. I suggest to you that the opposition to Mike Ward, the dissenting judgment, simply does not understand the importance of free speech in our society, the importance of the right to express oneself and to say anything that might lead to change, might lead to a different world. Remember, the left was always for free speech. Karl Marx started, his first publication was on free speech. The left opposed McCarthyism, opposed censorship, all of those things where there was repression against free speech. And it's very easy to understand why. Without free speech, you can't change anything. If you can't say something, you cannot change the world, you cannot change the atmosphere. And in fact, Mike Ward's position, what he was doing was attacking the sacred cows of our society. Céline Dion, Le Petit Jérémy, all sorts of people. He was attacking the sacred cows. It's an essential role in any society. In fact, what has happened now, when the left has turned on free speech, wrongly, I think, is that we take for granted certain positions, and you can't say the opposite. There is what is very close to a hate article in today's Devoir by José Blanchette about men, how terrible men are, how dreadful men are. I think she's got the right to say it. Not for a moment would I say that José Blanchette should not be able to publish her rant against men. I just ask you, would the Devoir have printed an incel guy saying exactly the opposite? Women are bum, 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 bum. Can't print it. You can't say it. The essence of free speech is that José Blanchette should be allowed to say it, and the incel guy should be allowed to say it. And the reason is because society might change. We take for granted certain things in our society. Is diversity a good thing? I'm going to tell you something, propositions that I think must be permitted, even though I don't share them, that diversity is a bad thing, that the traditional family is the way to go and women should be staying home and looking after children. I detest that idea. I've always detested that idea. But I think somebody who says it should be allowed to say it. And you see how far freedom of expression has been repudiated in our society when you consider you could do a list of things you can say and you can't say. And I'm taking no sides on it. You can say that there should be no Palestinian state. People say it all the time. The government of Israel right now, the new minister, Ben-Gvir, is a hate minister. Can you say that there should be no Jewish state? I'm not saying that. I don't believe that. I think you've got to find a compromise there. But you can't say it. You can't say it because there's this new definition of anti-Semitism, which means recognizing this. You can't say it means you can't argue for a different world, for a different change. And what has happened in our time is what I call the privatization of repression. After all the privatizations of Mrs. Thatcher, etc., now we've privatized repression. What does that mean? In the old days, the repression came from the government. You'd be arrested. Stalin would send the KGB after you, or Hitler would send the Gestapo after you, or the state would charge you with blasphemy and send you to prison, or Oscar Wilde ending up, well, that was not just talk, but still. The Marquis de Sade would not be printed by the state. Today, the state has very little to do with it. It's the private part, whether it's the Human Rights Commissions or anybody else, or the newspapers will not print you, will drop you, your university will dismiss you if you say something that you're not supposed to say. And the privatized repression of freedom of expression is particularly dangerous. So that's the background to the Ward state. The fact that you should be allowed to say it. And there's a principle behind freedom of expression. It's not important to have freedom of expression to say what everybody believes, to talk about how wonderful it is to have diversity, how wonderful it is to recognize all equal dignity, everything else. It's not necessary. What you need freedom of speech for is to say something outrageous. That's why Karl Marx militated for freedom of expression, because what he was saying was outrageous for the 19th century. Revolution coming, class struggle, the workers are going to take over, outrageous. He wanted freedom of expression to say it. That's why if you want to change something significant in our society, if you want to say that the direction our society has taken has been wrong, you need freedom of expression. So what Mike Ward said, he would agree himself, is outrageous. It's a joke, of course. It's a comedy show. Just like there was a famous guy who got away with it, got up in a cabaret in Moscow and said, contest for the best political joke. Third prize, 5 years. Second prize, 10 years. First prize, 20 years. He said it in public, and it was outrageous. That's why people laughed nervously when they heard him say something of that sort. And what we have is a systematic repression of freedom of expression. Every day in the newspapers and everywhere else, whatever's left of the newspapers, you have punishment. Somebody has to be punished for saying that. Apologize. The ritual of the constant apology. So I guess Mike Ward performed a service to this society by giving the context, which is a comedy routine. Nobody would believe it. You are allowed to say and make fun of outrageous things, of sacred cows of the society, of that sort of thing. Now, there are exceptions, and the Supreme Court doesn't deny the exceptions. The hate legislation, but remember the Keekstra case. Hate is not a word of casual connotation. It refers only to the most extreme and to the etc. So I personally, and let me say something outrageous, I would cancel the hate legislation. I think it's dangerous. But nevertheless, viewed the way Keekstra defines it, it's livable, it's acceptable, but only the most outrageous. There are exceptions for libel, but in libel you have to prove damages. And Mike Ward is still facing a libel case. There are exceptions for breach of privacy, but there again, if you disclose somebody's medical record on the air, there is a price to be paid. So what I think is the importance of the Ward case is two conclusions that came to it. First of all, artistic freedom is no different from other freedom. There's no special artistic freedom. That I interpret to mean, therefore, all freedom of speech has to be given a broad reading, because political freedom has to be given a very broad reading, and therefore it enhances the freedom of expression. There should be very few limits when it comes to that. The second issue is the statement by the Supreme Court, no one has a right not to be offended. There is a third important thing which Pearl raised a few minutes ago. Speech in itself is not discriminatory. Maybe hate at an extreme level, as Watcott would tell us, and as the Supreme Court supposes might be. But saying, for instance, somebody saying stupidly and idiotically, personally, I don't believe in racial equality, is not discriminatory. It's just stupid. And you can get up and say it's stupid, and that's all you have to say. But those are the things we've learned. Ward, by a thin 5-4, and Watcott, to a large extent, saved or attempted to save freedom of expression in a world in which so-called progressive forces, in the United States it's much worse, have decided that group equality, identity are more important than freedom. You can't change anything without freedom. So let's go, as I often say on other matters, but in this and freedom of expression, let's go back to Karl Marx and to John Milton and say freedom of expression is fundamental, and that's what the Supreme Court said. Thank you.
Julius is one of Canada's leading constitutional lawyers, but he's also a great public intellectual, and he and I have been arguing for 50 years, 40 years. Anyway, a long time, a very long time. I shouldn't be giving away anybody's age, but anyway, a very long time about these matters, and it's always a delight to have him in the same room. Couple of things to think about before I introduce our next distinguished speaker, Stéphanie Fournier. Is there a distinction between hate and incitement to discrimination? If I openly incite people not to rent apartments to folks who are of different color, if I openly incite advocacy or violence against people, is there a distinction between those two? And the second thing I want people to think about is unpopular opinion being offended on the one hand, and speech that actually causes harm on the other. Of course, when people are libeled or attacked or violence is expressed against them, they are offended. But that's not the legal criterion, right? You've got to have something more across the board. So a couple of things to think about as you're working through this session. So I'm going to invite Maître Stéphanie Fournier to come up. She's a lawyer at Quebec's Human Rights Commission, the Commission des droits de la personne et droits de la jeunesse, and she represented the Commission in the Ward case. She has, of course, represented the Commission through all levels of court, including the Supreme Court of Canada. She lectures regularly on equality law, publishes articles on various aspects of protection against discrimination, teaches at the École du Barreau, Quebec's Bar Association School, and practiced law with the Aboriginal Constitutional Law Directorate of the Quebec Department of Justice. She also clerked at the Quebec Court of Appeal with the Honourable Justice André Forger and the Honourable Justice Pierre Dalphond. And as I said, was one of the lawyers litigating the Ward case. I'm just delighted to have Stéphanie with us today. She's a litigator who has been in the trenches on this issue, and we're going to invite her to offer her perspective. Thank you very much, Stéphanie.
Thank you so much. I wish I was as fluent in English as Maître Gray is in French. He's so eloquent, and I'm really I'm admiring you. While hearing Maître Gray talking, came to my mind that quote from Spider-Man, the first version, I think, of Spider-Man. There's been so many. And where the uncle said to Spider-Man, with great powers come great responsibility. So we've been talking a lot about the right of the speaker, but what about its responsibility, his responsibility? If you do harm, don't you have a responsibility to repair the damage you've done? So there's a few points I would like to highlight about that very important case written by the Supreme Court. But what is this case not about? This is not a case about discriminatory remarks regarding a distinctive group. My court was not laughing about kids having Treacher Collins syndrome in general. He was targeting someone specifically. So this is about discriminatory and humiliating jokes targeting a 10 to 13 years old boy, publicly known for having bravely overcome his disability. And the Supreme Court of Canada provided us with a two-step test for resolving conflict between freedom of speech and the right to the safeguard of dignity. First, you have to ask the question, would a reasonable person aware of the relevant context and circumstances, will that person view the expression targeting an individual or group as inciting others to vilify them or to detest their humanity on the basis of a prohibited ground? And secondly, it must be shown that a reasonable person would view the expression, considering its context, as likely to lead to discriminatory treatment of the person targeted. That being said, I have to say it was hard, and you must believe I was deeply uncomfortable having to explain to Jérémy that as a kid, he had no protection against all the bad jokes about his disability made on the stage and on the internet as well. Having to explain to him that I know you thought, as a kid, that those jokes about that handicap that made you different were cruel and dehumanizing. But objectively, it seems that a reasonable person would not think so. I know you were hurt by your classmates who made fun of you while repeating Mike Ward's jokes, but it does not count because, objectively, in abstracto, A reasonable person would not think that such comments and jokes would lead to a discriminatory treatment. Since there was no social harm, the emotional harm you've suffered does not count. So the first point I would like to bring to your attention is we've been talking a lot about freedom of speech, artistic freedom, safeguard of dignity, but one piece is missing, and it's an important one. It's the right to equality. In that case, the right that was jeopardized from the Commission perspective was Jérémy Gabriel's right to the safeguard of his dignity in full equality. There is, we believe, and argued, a fundamental distinction between the right to the safeguard of one's dignity guaranteed under Section 4 of the Charter and the right to the safeguard of one's dignity in full equality. Unlike other human rights legislation across Canada, and apart from the Canadian Charter, the Quebec Charter sets out fundamental rights and freedom, as well as political, judicial, and economic and social rights, in addition to specifically stating the right to equality, and that's important. Not only does our charter recognize specific situations in which discrimination is prohibited and equally protected, such as, like Maîtres Eliadis mentioned, employment, housing, public services, access to public space, but it also recognizes that fundamental human rights are protected against discrimination. And in order to give its full meaning to the wording of the Charter, we have to conclude that discrimination is not the same thing as the violation of a right or freedom, in that case, as the violation of Jérémy's dignity protected or guaranteed under Section 4. And this principle was asserted by the Supreme Court of Canada in the Bombardier case in 2015, where the court, under the written by Justice Côté, mentioned, however, this requirement being the fact that equality right must be attached to another right or freedom, should not be confused with the independent scope of the right to equality. The Charter does not require a double violation, right to equality, for example, freedom of a religion, which would make Section 10 redundant. This means that the right to safeguard of his or her dignity is and must be different than a discriminatory violation of that same right. Professor Daniel Proulx, in one of his publications, gave an interesting explanation. He said that the harm required by Section 10 does not necessarily consist in the denial or violation of another right of freedom. Section 10 does not guarantee other rights and freedom as such, but ensure respect for the recognition and exercise of these rights and freedom in full equality. And he gave that example. If separate public schools were created for immigrants with facilities, conditions, services, and quality training equivalent to what is offered in public school, the latter could not claim that they are being denied their right to free public education guaranteed under Section 40 of the Charter. On the other hand, it is certain that the right to equality for students with a migrant background in the exercise of the right to public education would be impaired, since such a segregation based on their ethnic, national origin, or even on their race would necessarily be morally prejudicial to them, since they will not be considered worthy to attend the same school as Quebec native students. In Ward, the Supreme Court explained its vision, interpretation, and reading of the right to safeguard of one's dignity, but never provide an explanation of what is the right to safeguard of one's dignity in full equality. And the analysis of the case law that followed this decision takes up the court's analysis of the right of dignity, but neglects all the equality components. So, as the Commission regularly points out, the aim of the right to equality is not to recognize more right to someone that has to live with protected by a characteristic protected under Charter 10, but to ensure that he or she will not have less right or less recognition of his or her right because of this characteristic. The second point I would like to address with you is the question about the intent test. Reading the Supreme Court, the majority decision, lead us to believe that we're witnessing the introduction of the intent test in the burden of proof of discrimination. For those who are not familiar with the burden of proof to establish discrimination, it was well established by the Supreme Court of Canada that we have three components. Discrimination has three components that must be proved or established. First, we have to establish that there was a distinction, exclusion, or preference, that this distinction was based on a prohibited ground mentioned in Section 10 of the Charter, and that distinction is impairing the recognition of the right of freedom, or freedom, in this case, the right to the safeguard of one's dignity. And since 1985, it has been constantly clear that the intent to discriminate is not a governing factor in construing human rights legislation aimed at eliminating discrimination. Rather, it is the result of effect of the alleged discriminatory action that is significant. Intention to create a distinction or to exclude the plaintiff never was an element to establish discrimination. So in case of adverse effect discrimination, this principle is fundamental. This is why any rule or policy adopted by an employer or a service provider or anyone, and equally applicable to all of whom is intended to apply, may nevertheless be discriminatory if it affects a person or persons differently from others to whom it is intended to apply. The lack of intention to discriminate should not be a criteria to determine whether or not the rule is discriminatory. And that case I'm referring about was the Ontario Human Rights Commission versus Simpson-Sears, 1985 case, where the plaintiff was required to work periodically on Fridays evening and Saturdays as a condition of her employment, and her religious beliefs required strict observances of the Sabbath from sundown Friday night to sundown Saturday. The employer was not motivated with the intention to discriminate his employee. He adopted this rule because he needed staff to work on the weekend. But it was established that the work requirement imposing everyone without distinction to work on weekends, even though it was not aimed to create a distinction between employees based on their religious belief, was nevertheless discriminatory in its effect. So the onus shift on the employer to establish that he could not accommodate his employee without undue hardship, which he did not demonstrate. In the Ward's case, the majority upheld the trial judge finding of facts that Mike Ward did not choose Jérémy Gabriel because of his handicap, but rather because he was a public personality who attracted public sympathy and seemed to be untouchable. This is an interesting, or should I say, very frightening affirmation from the highest court. Should we understand from that affirmation that the motivation or the intent is now a criteria that must be established to prove discrimination? If so, we must conclude that we are witnessing a major, major setback in the protection of the right to equality. To assert that Mr. Gabriel was targeted by Mike's Ward comment because of his fame and not because of his disability, notwithstanding the fact that the remarks were specifically referring to his disability, in a very humiliating and degrading way, is ignoring the effect or the impact of those remarks on Mr. Gabriel. While reading the majority's opinion, one can only find that there's a narrowing interpretation of the right protected under Section 4 of the right to one safeguard of dignity. And human rights legislation should always, and it's a fundamental principle as well, should always be given a broad, liberal, and purposive interpretation rather than a narrow one. And in this case, one could argue that the interpretation given to both Section 4 and 10 is clearly a narrowed one. And it is interesting, and I'm just going to summarize very quickly. In 1996, in the decision Saint-Ferdinand, the court came with a very open and interesting definition of what is the concept of dignity under Section 4. Justice Leroux-Dubé mentioned that dignity has two components, one internal, one external. The external components refer to the humanity. So it refers to the respect to which every person is entitled to respect simply because he or she is a human being. And the internal component refer to self-respect, self-value, the respect that a person owes to himself or herself. And Justice Leroux-Dubé mentioned that the Charter doesn't make any distinction between those two definitions or components of the conception of dignity under Section 4. In 1999, under the law case, it was under the Section 15 of the Canadian Charter, but the Supreme Court also adopted a very large, generous interpretation of dignity, mentioning that it was also based on self-respect and the protection against unfair treatment. And this is why it's so interesting to observe that in the Ward case, the majority, without any explanations, I mean, not sufficient explanation, I would say, the majority ignores the impact of the internal aspect of the concept of dignity and narrowing its definition to only the external aspect I was mentioning with the two-step test it provides, so only considering the humanity of the person. And I will just say, to complete this point, that tribunals should always seek for substantive equality instead of formal equality. And I'm asking this question, by limiting the scope of the definition of dignity to humanity within each of us, are we moving away from that aim? Humanity is fundamental. It's among every person, but it does not take among our fundamental differences. That leads me to talk to you about the Schrenk case. That will be my last point. We've been talking a lot about many cases about free speech and discrimination, but one was left aside, and I don't understand why. That case was rendered by the Supreme Court of Canada in 2017. And I would like to make some comparison with that case and the Ward case. So a few words about the context in the Schrenk case. So the plaintiff, Mr. Mashgoul, worked as a civil engineer on a road improvement project. And Mr. Schrenk, the defendant, was also working on that project. There was no employment without relationship between the two men, but they both worked on the same site. So they were co-workers with different employers. And while working, Mr. Schrenk made racist and homophobic statements to Mr. Mashgoul. Mr. Mashgoul filed a complaint before the British Columbia Human Rights Tribunal against Mr. Schrenk, alleging discrimination on the basis of religion, place of origin, and sexual orientation. And it is interesting to observe that from the outset, the Supreme Court, do not hesitate to conclude that the discriminatory remarks constituted discrimination. In paragraph 2, the majority held that at issue then is the question of whether discrimination regarding employment can ever be perpetrated by someone other than the complainant's employer or superior in the workplace. To be clear, the issue is not whether Mr. Schrenk's alleged conduct would amount to discrimination. No one disputes this. Rather, the question in this appeal is whether such discrimination was regarding employment. And I conclude that it was. So the last question was really important because it determined whether the tribunal had jurisdiction or not, because as I mentioned previously, in other legislation, you have to demonstrate that discrimination arises within specific areas, within specific situations, such as employment, such as housing, such as public services. But in Quebec, the Commission position was that the interpretation must be broader because we have dignity that is guaranteed under Section 4. As I mentioned, Schrenk judgment was rendered in 2017, so only 4 years after Watcott. And the majority in that case made no reference to freedom of speech, no reference to Watcott, talked about no threshold related to the gravity of the remarks, no reference to the perception of a third party or to social harm. Right from the start, second paragraph of the judgment, the majority conclude that the impugned remarks amount to discrimination. They do so without considering whether the comment undermined the plaintiff's humanity, or if a third person would have considered that such remarks incite others to detest or vilify the humanity of the person targeted. The court adopted a large, liberal, and generous interpretation of Section 13 of the British Columbia Human Rights legislation and conclude that the scope of the protection provided by this disposition is not limited to employer-employees relation, but is extended to all employees who suffer discrimination, in this case discriminatory remarks, with a sufficient connection to or nexus to their employment. Knowing this, you can only imagine how proud and happy I was to bring that case before the Supreme Court, and argue that in Quebec, it is easier to establish discrimination in presence of discriminatory remarks or comments, because we do not have to connect them with a specific situation such as employment, housing, all of these situations being protected between Section 11 and 19 of the Quebec Charter, since the right to the safeguard of dignity is specifically protected. Unfortunately, as you know, the Supreme Court decided otherwise, and even though the Shren case was argued, the court gave no explanation and made no distinction with that case. So we are left with many unanswered questions, such as, well, if Jeremy had bought tickets to and attended Mike Ward's show, would it have made a difference from a legal point of view? If so, then what will be the difference between attending a show in person and watching the internet? Because, as I said earlier, Mr. Ward made videos that made fun. We're laughing in a humiliating way at Jérémy Gabriel and posted them on his website. So many, many, many questions out left. I can only hope that the best is yet to come. Thank you so much.
Merci beaucoup, Maître Fournier. Je vais inviter Maître Gray, Maître Fournier de venir s'asseoir ici en avant pour qu'on puisse répondre aux questions. I'm going to invite our speakers to come up and have the ability to respond to questions. Pour les francophones, évidemment, si vous voulez poser des questions en français, soyez libres et on va vous répondre dans la langue de la question. As you're thinking about your questions, and I'm going to be asking my colleague, Ms. Naranja, Cassandra, who's here with us today as well, to look at the chat. So if you're online, please do ensure that you put your questions in chat. Couple of points to set this up. One of them is that the concept of harm that was developed by the Supreme Court of Canada is going to be very relevant. Social harm that was developed by the Supreme Court of Canada is going to be something to think about, especially I'm thinking for the Max Bell students in the room, when you're thinking about the concepts of harm for the regulatory framework that the federal government is looking at to regulate harm. Will the government of Canada be informed by these concepts of harm and social harm that came from the Ward case? When you're thinking about these complex concepts of dignity, please also remember that we're going to be talking about the idea of dignity in detail in the second session as well. This concept of intent is really important, and I just want to flag for the non-lawyers in this group. The reason why intent is such a relevant concept in discrimination is that at the beginning of the regulation of discrimination laws in Canada, there was an intent requirement. It was a criminal issue, and there was a requirement, because it was criminal, that there be intent or mens rea. It was quickly discovered that it was almost impossible to prosecute. And so the reason why it is not relevant to look at the intent of discriminatory actions is because really what we're supposed to be focusing on is the impact, the demonstrated impact on people who are affected. So that, until maybe Ward, we're not sure, as Maître Fournier said, has been the law in Canada, and has that been changed. And very briefly, I just want to flag that there was a really important case that I think highlights the point that Maître Fournier made, and the point that Maître Gray made as well, with regard to this relationship between speech, intent, discrimination, and equality. Maître Tessier, who's the president of the Quebec Human Rights Commission, is here, and he's going to be talking to us later about a case called Calego. So I won't go into any detail about it, but I just want to flag that it was a really interesting case where the Quebec Court of Appeal said, in response to racist comments made by an employer against Chinese workers, saying that these people were inherently unclean, that these people needed to go back home, and that it perhaps where they came from, that these were not the appropriate cleanliness standards, essentially racist comments. Now, it was made in the context of employment, so to Maître Fournier's point, but the court didn't make the decision based on employment. The court made the decision based on this concept of dignity. And dignity is one of the cornerstones of human rights law, and always has been since the Universal Declaration of Human Rights in 1948. So with those sort of concepts in mind, I'm going to invite first people in the room, questions, comments for either Maître Gray or Maître Fournier, or both. And perhaps, Cassandra, you could flag us if there's anything online as well. So in the room first. Yes.
It's good? It's working? Thanks. It's a question for Maître Gray. If legal argument is the art often of making distinctions and trying to clarify those distinctions between two things which might appear similar, I think one would expect, especially from a law professor, that he would go out of his way to clarify distinctions. I found that Maître Gray was clouding lots of things and mixing apples and oranges, so I'd like to give him a chance to redeem himself. The whole basis of the argument that Maître Gray was making had to do with the concept of freedom of speech. But I would suggest that Maître Gray was mixing all sorts of concepts of freedom of speech together interchangeably. Freedom of speech, in terms of the examples he gave, were very often what we would today call criminal examples, where people, the government or the powers that be, would imprison people, would kill people, would banish people, printing presses would be destroyed. The government, as an agent, said such kind of speech is illegal. I'd like Mr. Gray to qualify that that of course has nothing to do with the Ward case, that there was no criminal action against Mr. Ward. The government was not prohibiting him from talking, that the Commission des droits de la personne et des droits de la jeunesse would have no jurisdiction to hear criminal law of any sort. Mr. Gray mentioned various other examples of libel and defamation of things which aren't criminal, but continue to wrap himself in this flag of freedom of speech without distinguishing. So I'd like him to be able to confirm that the freedom of speech is not an all-encompassing concept, that there was no criminal issues here, there was no hate speech issues that were dealt with by the Supreme Court in terms of their conclusions, and that it was mostly a question of interpretation, statutory interpretation of what a particular article of the Human Rights Commission, of the Human Rights Charter allowed or didn't allow, which was talking about the consequences of speech, but not criminal consequences. And that and this is really not a legal decision on freedom of speech, undefined, but a decision having to do with non-criminal consequences of the exercise of certain kinds of speech.
I think you're dead wrong. That's exactly the distinction I made, or not a distinction I made, but the point I made about the privatization of repression. In the old days, the repression was indeed the state, but the private repression is just as bad. Today, when you get canceled, when you get removed from your job, when you can no longer perform and so on through semi-private or private agents, it's just as much of a repression. The repression of freedom of expression after privatization is the natural consequence of neoliberalism. Neoliberalism privatized welfare and social justice and so on to the point where they're creaking and they might collapse. And now the so-called left in the United States and everywhere else is privatizing repression of of freedom of expression. But freedom of expression cuts across both. Libel, of course, is there. Libel looks at consequences, but you have to prove damages. The real distinction is in discrimination, that you can order people not to discriminate, not to refuse to sell to somebody, not to refuse to hire somebody, not to say things at work which make it impossible for somebody to work. The further question, what they want to say is that you must, in the name of some vague concept of dignity, tell somebody that you agree with this rule. I agree that there should be diversity. I think a person is entitled to say, I don't want to be selling to you, but I have to because of the Human Rights Act. If he doesn't sell, then he commits an offense. But you are allowed to offend people. If you make a rule that only the consequence counts, in other words, if somebody's hurt by what you say, then that's good enough, then you will be effectively removing freedom of expression from the society. Let me give you an example. When I came to Canada at the age of 9, I didn't speak English very well. I was put in English school, and for the first few months I was completely silent. The kids called me dumb, literally, because I couldn't speak. But afterwards, they mocked my accent. And one person who remained a lifelong friend forever mocked my accent beautifully in grade 4 or 5, and perhaps it was a little humiliating. But should you have said it's an offense? It's something that shouldn't be done? Well, the answer is remains a good friend. He was funny. And yes, it was a little hurtful at that point. That's not what you can repress. So let's go back to it. You can make sure that discriminatory acts in employment, selling, commerce, admissions to institutions cannot take place. You can certainly insist that it can be indirect as well. In Caligo, the issue was that the employer said some things, and that makes you it makes it very difficult to carry out the work afterwards. Although he just had an outburst. He didn't say anything particularly racist. He said a 2-minute outburst, but I think correctly an employer shouldn't do that. The fact that somebody says something, if somebody says, I do not agree with our anti-discrimination laws, might be humiliating for the person. I don't believe in racial equality. Stupid, but you are allowed to say it. I don't believe in diversity. And otherwise, let me bring to you, it becomes a matter of different lobbies that enforce their views. And the successful lobbies enforce their views successfully. The unsuccessful ones do not. The reason why José Blanchette can afford an attack on men, but an incel gentleman couldn't have an attack on women is because one lobby is more powerful than the other. In fact, both are idiotic and both should be permitted. And the reason why you cannot say that there should not be a Jewish state, but you can say that there shouldn't be a Palestinian state, is because one lobby is more powerful than another. In fact, both positions should be listened to, and you shouldn't bring in that UN definition of anti-Semitism, which is idiotic. Again, I repeated the word idiotic several times, because once you say that all that matters is the effect, and if somebody is hurt or humiliated, you should be punished or in some way or financially or other ways for saying it, there is no freedom of speech left at all. In fact, Ward, and let me just say one thing, Ward was preceded by another case which said very much the same thing, Bombardier. Bombardier said, if the purpose was not to discriminate, but to fulfill the United States security reasons, then it wasn't discrimination. And there were nuances in Bombardier, there are nuances in Ward. But the answer is mere speech is not discrimination. It has to have some effect on services or admissions or employment.
So before we go to the next question, I think we need to give Maître Fournier the opportunity to respond. I can see her. That's right, so please, thank you very much.
I would like to point out something, one particular aspect, and that is what I mentioned at the beginning of my presentation. There is a difference between, on a legal point of view, there is a difference between talking about Black people, saying outrageous comments, and targeting someone specifically. And why is that so? Because the Quebec Human Charter provide us guaranteed fundamental rights. So it's not collective right, it's individual fundamental rights. So freedom of speech on one part, and the right, well, it was right of, to safeguard of one's dignity on the other end, but it could be the right to reputation, safeguard of one's reputation, or the right to privacy, as Maître Gray mentioned. So when you have two opposing rights that you need to conciliate, how do you say? To reconcile, thank you. Well, this is where balance came in. This is the role of the tribunal, to try to reconcile those two rights. But it is really different from the criminal perspective. So it's really, you have to understand that rights are individual. Ce sont des droits individuels, yeah? Okay, yeah. And that makes a huge difference on a legal point of view, because that was our perspective. That's what we argued, that Jérémy had right, and that right that was guaranteed by the Charter need to be recognized. We need to be protected, and we need a balance between these two.
Is there anybody else in the room who would like to ask a question? Yeah, and I'll ask everyone to, if possible, keep your questions and keep them relatively brief. Thank you very much.
I have two questions, and I'll keep them both very brief. So as a literary scholar, I'm curious, how important is genre in making this decision? The fact that it's a comedy routine with a very classic setup even, right? Leading up to a particularly shocking punchline. Was that important from a legal perspective in terms of the decision that was made? And then the second question is, what would have been the concrete consequences for the two individuals involved if the court had made the opposite decision?
I'll say two things. First of all, the context does matter. For instance, I agree, somebody brought up that issue before. If you get up in front of an angry mob and say, let's go and demolish a synagogue or a mosque, then you're committing an offense. Just like if you tell people, let's go and help ourselves to what's being sold at a department store without paying for it, you're not allowed to incite crime. So the context does matter. Although in this particular case, the comedy show is clear. He said it's a comedy show. It was for adults. You bought tickets. He never suggested that he tried to kill Jérémy or that. So, of course, it's important. And it's one of the factors, because otherwise you could fall into hate if you go the other way. The consequences the other way would be the chill factor. And that comes in the case of Rocket and the Dental Surgeons College of Ontario, where they said you cannot advertise at all, and the person advertised. And the Supreme Court, the argument of the College of Dentists in the Supreme Court was, well, we'll do it on a case-by-case basis. We'll see that reasonable things can go by, etc. And the court, Madam Justice McLaughlin, said, no, the chill factor is so great. There are so few professionals who are going to want to risk getting into a fight with their professional body that nobody will talk at all. And the consequences of the opposite conclusion is there can be no comedy show, because comedy shows are only funny if they're mordant, if they're nasty. People don't laugh not very much at goody-goody jokes. So if you're always running the risk that somebody says, wait a minute, my dignity, then it's the end of that sort of artistic thing. And it's also the end of all freedom of expression if the effects, whatever your intentions are, somebody says, but you hurt me. No. It has to be, in a libel case, you have to prove the damage. And even there's a famous case of Torstar, which has to be looked at. The Supreme Court said, libel, you can repair the damage, but you have to consider freedom of expression even in libel. And therefore, nasty or incorrect things can be said, so long as they are not so extreme as to actually hurt you. And so that even in libel, the freedom of expression must be weighed.
I'm going to invite Maître Fournier just to comment briefly, and on the goody-goody jokes, I'm going to cancel all my chicken cross the road jokes today. None. Maître Fournier, and then we're going to close for a brief break.
Yes, context is important, but if you consider context, like you said, a comedy routine, you have to consider the fact that the targeted victim was a 13 years old boy, and that was not considered, that was put aside and not considered enough by the Supreme Court of Canada. So that is an element. So what is the scope of the dignity of a 13-year-old boy? And how could you say that, okay, it's okay, Mike Ward can say those things, but I have to tell my kids, you're not allowed to say the same thing in the schoolyard. So what is the difference? So the context will be, okay, it's because it was on a stage, or because, so is it the intent? As I mentioned, intent should never be part of the equation to determine whether or not there was discrimination in that case, in any case, discrimination case. So if you consider context, you have to consider both sides of the context. That is really, really important in discrimination.
Thanks very much. Just before we break, I think we have one question online, so we'll ask for that question and then brief responses from our two colleagues, and then we'll go to break. Thank you.
Hi. So this might be a question relating to, I guess, discourse and critiquing free speech violations or purported free speech violations. Bing asks, putting legality and freedom of speech aside, there are millions of possible jokes one can make. Ward insisted on making those that causes great distress to someone. Seems that he is not very good in comedy and lacks the ability to create jokes that don't cause mental distress to a kid. I would consider him to be a terrible comedian, but how far are we able to make fun of him for that?
As far as you want. I've never defended the aesthetics of the show. I wouldn't have done that, but I might have said something else that would have also hurt people. And I have in public come out and said things opposed to the Me Too movement. Right? You're allowed to hurt people as long as you do not discriminate against them in services, employment, or admissions to places.
I would go on that and complete my previous answer, saying what was particular in that case is that Mike Ward was laughing, humiliating Jeremy based on his disability. And that was the point. When Mike Ward say, you don't sing well, that's no discrimination. And in his routine, he was laughing about Grégory Charles. I don't know if you know him. He's a well-known artist. He's a black man. And he's been laughing at him, but never did he mention anything racist about him. So that's the whole point. That's the difference. When you use language, when you use free speech to put, mettre en exergue to highlight someone different based on his a prohibited ground. Well, this is the difference here that was the Commission's position, the limit where free speech should be put aside to protect the dignity and full equality of someone.
Remember, he did attack Céline Dion. He said she was ugly, and nobody
That's
would.
no discrimination.
Well, it could be. Again, body shaming, lookism, those are things that could be considered discriminatory, I think are.
Lookism, by the way, is not in either the Canadian Charter of Rights and Freedoms or the Quebec Charter of Rights and Freedoms.
No, wait a minute,
Bonsoir, Claire.
it could be interpreted to be included in various things about even in handicap. The fact is that mocking somebody saying she's ugly is as humiliating to her dignity as anything else. He's allowed to say it. It's, again, not something, from an aesthetic point of view, I wouldn't do it. But then I never wanted to be a stand-up comic.
Maître Fournier, you get the last word. 2 seconds.
So this is why it's so important to make the distinction between the safeguard of one's dignity and the safeguard of one's dignity in full equality.
We're going to be back at, Thanks very much for that spirited exchange. Apologies to those.